is file 45-315-FH, People of the State of Michigan versus Michael Deshane Dunn. We are here today for arraignment on a warrant for failure to appear. Sir, you are Michael Deshane Dunn?
Yeah.
Mr. Dunn, have you received a copy of your warrant?
Yeah.
The warrant alleges that you failed to appear for your sentencing hearing on October 3rd, 2025 at 8:15 a.m. That would be considered a contempt of court. The maximum possible penalty for contempt of court is up to 93 days in jail or $7,500 in fines. You are entitled to be represented by an attorney today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from our public defender's office. Do you understand that?
Yeah.
Would you like to be represented by an attorney today?
No.
Do you understand that you have a right to contest the contempt of court charge and to have a trial on it?
Yeah.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yeah, I understand.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes.
You have the right to testify at your trial. I'm sorry, you have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that?
Okay.
How do you want to plead to the charge that you failed to appear for sentencing on October 3rd, 2025?
Not guilty.
All right. Ms. Clark, we'll need to set this for a hearing. Can we have a 1-hour hearing time then?
Yes, Judge. We could do Wednesday, May 27th at 3:30.
Sorry, did you say 3:30?
Yes.
So we'll set this for May 27th at 3:30 p.m. Francis, could you also bring me the red folder? I
Yeah.
need to set a sentencing date.
Your Honor, if I may.
Yeah, Mr. Milano.
On Mr. Dunn, are we expecting additional charges out of him being picked up on this case?
Do you represent him on the underlying file?
I do.
Okay. I don't have any idea. Do you want to have a breakout?
Yes, please.
We have Mr. Malaro and Mr. Dunn back from the breakout session. Mr. Malaro, is there anything we need to address in setting a sentencing hearing?
Judge, I would just ask to set the hearing at the same time as you've set the contempt. And perhaps we could set it for the morning or something on the 27th.
Okay, Ms. Clark, do we have anything available on the morning of the 27th?
That's our regular criminal docket day on Wednesday.
All right, so we're not going to be able to accommodate it on that day, Mr. Malaro. We can do it at 3:30, or we can look for a different day.
3:30 is fine.
All right, so we'll set the sentencing as well. Well, do we have a PSI for Mr. Dunn?
We do, Judge.
Okay, so we'll set the sentencing and the contempt hearing for May 27th at 3:30 p.m. Mr. Dunn, you can let the officer with you know that you're done with court for today.
Thank you, Judge.
All right.
All right. Yes, thank you. Bye.
Are we ready to proceed to Mr. Sons?
Yes, sir.
All right, this is file 09-14191-FC, People State of Michigan versus Marshall Scott Sosby. We are here today for sentencing in this case, and we are proceeding today partially in person and partially by video conference. I do have one person, Samantha Moore, I know where it is, I think going to make a big impact statement, who's attending by Zoom. I do have Ms. Moore in the Zoom session now. So can I have the attorneys place their appearances on the record?
Jennifer Bruggeman on behalf of the people.
Good morning, Your Honor. Allison Swain from the State Appellate Defender's Office on behalf of Marshall Sosby. Marshall Sosby is here in person today.
And sir, you are Marshall Scott Sosby.
Yes, Your Honor.
Mr. Sosby, have you had an opportunity to read and review the pre-sentence report and the updates to the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to discuss those reports with your attorney?
Yes, Your Honor.
Wish to explain or challenge the accuracy or relevancy of any of the information that is in these reports?
No, everything's good. Thank you.
I'm sorry to interrupt. I just want to make sure that Ms. Moore is let in She wanted to be present for the entire sentence.
She is in session.
Okay,
She doesn't have her camera on, so
I see, okay,
so you're not gonna see her up there, but her device is, in the Zoom session and her audio is connected.
okay, thank you.
The pre-sentence report did not disclose any prior convictions, or any with a known constitutional defect. And sentencing guidelines in this case are calculated 225 to 375 months. Ms. Brookman, do you agree with that computation of the guidelines?
I agree with the totals, Your Honor, but as I indicated in my sentencing memorandum, I do believe that OB3 should be scored at 25 points. That doesn't affect the guideline minimum range, but I do believe that that would be appropriate, given that we can't score 100 points since this is a homicide offense, but under People v. Houston, which I cited in my sentencing memorandum, that at 25 points is appropriate in instances when a victim is killed. And we have 2 victims here, but I do believe that 25 points is appropriate, and I would like that to be scored. It's currently scored at 0.
Ms. Swing?
Your Honor, I believe, given that it doesn't change the range of the sentencing guidelines, we have no objection at this time for that.
All right, 25 points is appropriate under OV3 where there was life-threatening permanent incapacity that occurred to a victim. People cite People versus Houston, 473, Michigan, 399, 2005 case for the proposition of scoring 25 points for life-threatening or permanent incapacitating injury was proper in a second-degree murder, even though the victim was killed. So it does appear appropriate to score 25 points. Will be 3. That does not change the minimum guideline range because we were already at the maximum minimum guideline range, and so it remained at 225 to 375. Any other issues with the guidelines, Ms.
No, Your Honor, thank you.
Does the defense have any guideline challenges?
No, Your Honor.
Before the court has a sentence, then Ms. Swain, is there anything you want to say on behalf of Mr. Sosman?
Yes, Your Honor. I first want to take a moment to acknowledge the tremendous loss that the Sosby family and so many others experienced by losing their loved ones, Carmen and Michael Sosby. Marshall's actions killing his parents were senseless. His siblings should have never had to endure that loss at such a young age, and his grandparents should not have had to have buried their children. We are here today because the Michigan Supreme Court held in People v. Stovall that a life with parole sentence for an offense committed by a child violates the Michigan Constitution's prohibition on cruel or unusual punishment. At the time of this offense, Marshall was 17 years old. He was a scared, immature, and impetuous kid. Today, Marshall is 35 years old. He has grown and matured from that abused 17-year-old into a remorseful and thoughtful man. He spent the last 17 years participating in programming, bettering himself and those around him. He has spent that time self-reflecting and living with the pain of this offense. When fashioning a new sentence for Marshall, there are many considerations for this court. A sentence must be proportionate to the offense and the offender. People v. Boykin and People v. Eccles require this court to consider the mitigating characteristics of Marshall's youth at the time he committed this offense. Boykin tells us that youth necessarily impacts the analysis of the Snow factors, reformation of the offender, protection of society, and discipline of the wrongdoer. Finally, while this court is not required to make findings as to the Miller factors inform the analysis of the mitigating characteristics of youth outlined by Boykin. I know I filed a lengthy sentencing memo, so I don't plan to re-argue everything here, but I want to talk a little bit about the relevant Snow factors and Miller factors as they apply to Marshall. I also want to be clear that none of the arguments I make are meant to be excuses for Marshall's horrible actions. Still, Miller requires us to consider what it defined as the mitigating qualities of youth, which include a youthful defendant's background, mental, and emotional development. The first Miller factor is chronological age and its hallmark features of youth. Marshall's chronological age is mitigating. He committed this offense when he was 17 years old. Our case law tells us that youth is always mitigating and must be considered for its mitigating impact. The brain science tells us that adolescents, compared to mature adults, have a reduced ability to control their impulses in a complex or emotionally charged situation. They also have a reduced ability to manage their emotions, and they place more value on the potential benefits of certain behavior rather than fully considering the risks. The inability to recognize certain behaviors or situations as risky or wrong can be exacerbated by early traumatic experiences. Marshall's age alone is mitigating and mitigates in favor of a sentence of 225 months on the homicides. The next Miller factor is the circumstances of the family and home environment. This case is unique because Marshall killed his own parents, who subjected him to extreme abuse and neglect. It may sound like I'm making excuses or justifying their murders, but that's not the purpose of talking about what it was like for Marshall while growing up. The law is clear that this factor is relevant to juveniles' characteristics of youth. Even if Marshall hadn't killed his own parents, what he experienced in his home as a child and growing up is significantly mitigating and would be relevant to this court when crafting a proportionate sentence. Miller tells us that a juvenile's circumstances of the family and home environment are relevant because children are more vulnerable to negative influences, including those from their family. They have limited control of their own environments and lack the ability to extricate themselves from horrific crime-producing settings. Marshall's father was abusive towards Carmen and his children. When Marshall was 3 years old, Michael, his father, knocked him down because Marshall got in the way of him threatening his wife with a machete. Growing up, not only was Marshall unable to extricate himself from his father's horrific abuse, but even his mother was frequently unable to leave and keep her family safe. The abuse was so extreme, Carmen tried to escape her husband's abuse on several occasions, fleeing to different states and even out of the country. Marshall grew up with an emergency backpack, something like his mother also had, in case they needed to escape for safety. Because of her own abuse, Carmen did her best to care for her children, but there were times when she left on her own, leaving Marshall and his siblings behind. On some of these occasions, Michael would have Marshall call his mom and beg her to come back. The escapes were never successful. They always ended up with Marshall's parents getting back together, and the violence would continue. Marshall grew up near his paternal grandparents and who would try to protect the children when they could, but Michael frequently would not let his parents see their grandchildren if they were trying to intervene between him and his wife. As he grew up, Marshall experienced abuse, like his father handcuffing him to his brother, holding him underwater in a pool, using a taser and electric collar on him as punishments. In the year leading up to this offense, Marshall's father, holding a 9mm gun, ordered Marshall outside and to face away from him. Michael shot Marshall in the back, causing him to fall to the ground. It wasn't until his father was standing over him that Marshall realized his father had switched out the Smith & Wesson for a paintball gun. Marshall grew up in tremendous fear of his father. He felt protective of his mother and wanted to help, but he was a child who also needed to be protected. And he was not getting that from the adults in his life. He spent a lot of time alone, retreating to the comfort of video games, fantasy worlds, and online friendships. He experienced things no child should have to experience, especially by the person who is supposed to be his protector. He saw things that no child is supposed to see. What Marshall experienced as a child, both trauma and neglect, mitigates in favor of a sentence of 225 months for the homicides. The next Miller factors are the circumstances of the event and the ability to navigate the criminal justice system. On September 23rd, 2008, Marshall got into a fight with his father about his cell phone and unjustifiably shot and killed his father and his mother. Marshall then threatened his sister Samantha's life when he pointed a gun at her and told her not to tell the police what really happened. He initially denied his actions, lying to police. Following the offense, Marshall was found to be incompetent for trial for a period of time. He was admitted to the Center for Forensic Psychiatry before he was eventually restored to competency. Marshall then pleaded guilty to second-degree murder and apologized, taking accountability for his actions. Today, he takes full responsibility for killing his parents and is incredibly remorseful for the harm he caused his family and other loved ones. While the context of the strained and abusive relationship with his parents is relevant for this court's consideration, Marshall by no means argues that this excuses his behaviors. This court will hear directly from Marshall in his own words about how remorseful he is for the harm he has caused. The final factors are sort of addressed together. The Miller factor is the possibility of rehabilitation, and the Snow factors of reformation of the offender, protection of society, and disciplining the wrongdoer. All of which are mitigating as to a term of 225 months for the homicides. Adolescents grow and change. Case law tells us that rehabilitation involves the successful completion of vocational, educational, or counseling programs designed to enable a prisoner to lead a useful life free of crime when released. That's People v. Bennett. Case law also tells us that the Snow factors must be viewed through the mitigating lens of youth. As to the Snow factor of reformation of the offender, People v. Boykin tells us that, quote, an adolescent's greater possibility that his character deficiencies will be reformed necessarily transforms reformation of the offender, end quote. As to protection of society, Boykin tells us that a youth's heightened capacity for change compared to adults necessarily impacts the consideration of protection of society. When it comes to the Snow factor regarding discipline of the wrongdoer, Boykin tells us it's less supportable to conclude that even a heinous crime committed by a juvenile is evidence of irretrievably depraved character. Finally, as outlined in the sentencing memo, Case law tells us that deterrence cannot be measured for the same reasons adolescents are less culpable. They are less likely to consider punishment. All three relevant Stowe factors contemplate that adolescents change. Marshall's reformation, rehabilitation, heightened capacity for change, and how he's been adequately disciplined for this offense are all demonstrated through the work he's done when he's been incarcerated for the last 17 years. I want to highlight just a few of his accomplishments over those years and the work that he's put in the last half of his life and why he's deserving of a sentence of 225 months. First, I want to touch on Marshall's MDOC disciplinary record. In 17 years of incarceration, Marshall has incurred only one Class 1 misconduct and only 9 misconduct tickets total. He's been at the lowest security level possible for the last 12 years. His misconduct record is below the average for an incarcerated inmate in Michigan. His record is especially exemplary because we know that juveniles earn a lot of those early misconducts in the first years that they're incarcerated. And not only did Marshall not rack up a bunch of misconducts, he has been consistent over time. Next, I want to talk about Marshall's programming and education. In 2010, he earned his GED in prison. He's currently enrolled in Jackson College and is a member of the Honor Society. Marshall has meaningfully engaged in as much programming as has been available to him. Early on, Marshall sought out involvement in programming to better himself and change his way of thinking. He established himself as a leader and a mentor and became a facilitator for many programs after he took them. There are many letters of support from other incarcerated individuals attached to the pleadings before this court. The list of programming that Marshall has been involved in is extensive and also before this court in the pleadings. Notably, he's participated in programs like Cage Your Rage, effective communication, personal dynamics, healthy relationships, critical thinking, and much more. Marshall has instructed or facilitated programs like critical thinking, conflict resolution, and inside out programs with college students. Most recently, Marshall finished a personal integrity course and earned a 4.0 in his English course. In terms of trades and job readiness for when he comes home, Marshall has participated in study courses like commercial driver's license, advanced business, real estate, small business, and programs like computer science, legal research, Money Start computer-based instruction, and Build Your Own Financial Future. Marshall has also been involved extensively in the Prison for Creative Arts program, also known as PCAP, through the University of Michigan, participating in creative writing and theater. As we think about Marshall's future, he recognizes how lucky he is to have had the support of his grandfather until his grandfather passed last year, and to have the support of his grandmother. Over the years of his incarceration, his grandparents were his biggest supporters. Today, Marshall has a network of people who are ready to support him. His grandma is here today. Many members of the Sado reentry team and Sado are here also to support him. When Marshall is released, he plans to live with his grandmother, or to Marshall, his Oma. Oma is eager to welcome Marshall back into society and has a bedroom set up for him in her home. Marshall also has the support from his brother Tristan, who he has been able to foster a relationship with over these years. He has the support from Sado's Project Reentry and PCAP professor Dr. Ashley Lucas through PCAP's reentry program linkage. In summary, as People v. Milbourne tells us, imposition of the maximum possible sentence in the face of compelling circumstances would run against the concept of proportionality. An analysis of the Snow factors and the Miller factors here demonstrate that a proportionate sentence is 225 months on the homicides. In the majority of cases where an adolescent committed first-degree murder, the sentencing range is 25 to 40 years on the minimum. Marshall took responsibility and pleaded guilty to second-degree murder when he was still a child. Sentencing Marshall to a sentence that is just as harsh or even harsher than the range for first-degree murder juvenile would be disproportionate. Marshall has used each year of his incarceration to better himself and those around him. Just as the law has indicated that he would change, just as the law has indicated he had a greater possibility for reform, he has demonstrated that. It is evidence in his programming, education, and work history. As to deterrence, the case law tells us it's nearly impossible to measure deterrence when it comes to adolescents because the same characteristics that render juveniles less culpable than adults makes them less likely to consider potential punishments. When it comes to protection of society, Marshall has been housed at the lowest level of security available to him for the last 12 years. In 2012, just a few years after arriving to prison, Marshall's risk assessment on a prison evaluation posed such a low risk for violence, MDOC removed him from the waiting list for mandatory violence prevention programming, as he did not need this because of his low risk score. The law tells us he has a heightened capacity for change, and he has changed. As to disciplining the wrongdoer, Marshall has been incarcerated since 2008. His actions are not those of an irretrievably depraved character, but instead a desperate, angry, and abused child. Marshall knows that when he killed his parents, he destroyed his family. In addition to his years incarcerated, Marshall is tormented each day knowing he is the one responsible for taking the lives of his parents. While there is nothing he can do to bring them back, and nothing he can do to heal the wounds he has already caused to his siblings, his grandparents, and the community, Marshall has already dedicated himself to giving back and has no plans to stop once he is home. Where he's availed himself to give to as much programming as possible, mental health treatment, and seen as a mentor, additional incarceration at this point is just that, punishment, and serves no further rehabilitative purpose. The guidelines that govern this case were scored aggressively and reflect the aggravated nature of this crime. Marshall has demonstrated the rehabilitative ideal. For these reasons and the reasons put forth in my sentencing memo and appendix, I'm asking this court to resentence Marshall to 225 months on the homicide offenses.
Thank you. Mr. Sosby, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor. I was a horrible person who created a void and destruction within those I loved and cherished and in my community. When I took the lives of my mom, Carmen Sosby, and my dad, Michael Sosby, my actions also caused feelings of betrayal. My actions also caused feelings of betrayal, pain, suffering, anger, and unthinkable fear. This especially was and is felt by Samantha, Devin, Tristan, and the rest of my family. Because of my actions, my siblings needed therapy and support from one another to just handle their daily lives. I don't know what my parents may have felt themselves seeing me, their oldest son, holding a gun, pointing it toward them. I imagine Dad felt confusion, rage, and sadness. My mom, her husband killed. I imagine she was overwhelmed with betrayal, grief, sadness, confusion, gut-wrenching pain. Never truly be able to correct what I've taken and the emotions of pain I place on my family, friends of the family, and society on that horrific day. Tristan, Mama told me about how you took your shoes off and said, Mama, get at home. On that perfect day, you were so young, and what happened didn't dawn on you. You slowly learned that they were never coming back. I know you were picked on at school because of your parents were dead. Seeing your friends spend time with their families during holidays, when it reopens a wound, you'll never have those moments. You'll never experience having our parents. You've never had a chance to have the conversation you could have had with them. And now you just had a son, and I know your son will never get a chance to know their grandparent. I'm so sorry. So sorry for making you go through life with shattered pieces and never knowing how to put them back together. Devin, you were always the one with the golden heart who never wanted to hurt anyone's feelings. On that heroic day, you had no idea this would happen. I can only imagine your fear, terror, and confusion as you heard gunshots and saw Dad and Mom die on my hands. You saw how much I love Mom, yet I killed her. You might have thought you were going to die too. I traumatized you. I betrayed you. At times, I wondered if you moved out of state to get away from all of this. I know this is something you don't want to relive, and our parents weren't there to see your accomplishments. They weren't there to see you finish high school, get married, have children, become an amazing dad. In the Navy, become a state trooper, or start your own business. I took that opportunity from you. I caused a tornado that went through. It remains your whole life in a horrible way. I'm sorry. Samantha, I made you feel like you were going to die. I tore your soul apart. I was your reaper. It was like a horror movie for you. You saw me take Dad's life. I was your champion. And then you saw me take the life of Miles, someone I cherished. And you thought you were next because I threatened you. I know this fear that you've been living with your whole life, your whole world, has shifted again because of my resentencing. I don't want you to live in fear. I want you to find peace, security, and stability that I've taken from you because of my actions. I've put a wedge between you and our grandparents, bridges for everyone in our family. I took away the possibility of memories that could have been. I'm sorry for being a horrible brother to you. I'm sorry for being a monster. I'm sorry I took the lives of our parents. To one grandma. I dropped the emotion battlefield on you. Parents should never have to bury their own children. You had plans for your own graves, but you had to buy plots for Mom and Dad. You had to go through Mom and Dad's house and clean it. Wounds reopened again and again. You thought you were done raising kids, but now you're raising 3 more in your retirement years. But both of you were more worried about everyone else than yourselves. At the beginning, I wanted to push everyone away because I didn't deserve anyone. But you never gave up on me. You did what many people would never be able to do. You were always there for me. You never judged me. Thank you. Thank you for helping me, man. I am today. Grandma, I know you're no longer with us, and I want you to know you don't have to worry. If I'm given the chance, I'll be there, and I will take care of Oma. I'm sorry. I'm so sorry. My crime affected everyone. Just reading about it in the paper made people wonder, what if? I made the community start locking up their homes and locking up emotionally. I can't undo what I did, so I wish I could. I realize that all the words I'm speaking today are not enough. I can't go back in time. I failed my family. What I can do is to strive every single day to be the person my family and community deserves. Today, I'm a man committed to continued growth of my journey of transformation for myself and those around me. I can now reflect and recognize how my daily actions impact others. I thank Jehovah for placing people in my life who have helped shape me into the man I am today. I'm grateful for the opportunity to take accountability for my actions and share these words today. To everyone I've harmed, I'm sorry.
And then do the people wish to.
Yes, Your Honor, do you want to be heard by me or Samantha?
Whichever you prefer.
I would probably prefer that Samantha be able to speak first.
All right, Ms. Moore, if you are there, I'm going to send you a request to unmute your device.
I'm here.
Okay.
I'm
sorry. I'm sorry to interrupt, but I'm going to send you a request to start your video. If you prefer not to start your video, you don't have to accept that.
I would much rather not.
Okay. If you would just state your full name and then you can continue with whatever it is you would like to say.
My name is Samantha Moore, previously Samantha Sosby.
All right, you can go ahead.
Okay. I have prepared a statement. After hearing everything, I have made adjustments because I do feel that this court has never fully heard the truth. I will begin now. My name is Samantha Moore, previously Samantha Sosby. I am the sister of Marshall Sosby, who I will refer to as my older brother from here forward to avoid using his name, so I am able to get through this statement. Using my older brother's name in any sense creates significant distress for me, which may affect my ability to remain focused. While providing this crucial, never before heard in this case statement, I have even covered him with a sticky note because I do not want to see him. For this reason, I will refer to him in general terms. I understand that this defense and criminal heavily rely on the victims to be too scared to relive these memories so that they may then paint their own images of what happened. So I am here at the risk of reopening these disturbing memories to relay the full truth. I am submitting this statement after many years of being unable to speak on these matters in a formal setting. Since the horrific tragedy, I have not felt able to testify or provide input in proceedings involving my brother. When I was a minor, I was not permitted to testify in court by my grandparents. And over the years, I have struggled with fear and distress when even receiving correspondences related to the case. I am here now to tell you plainly and without apology how my brother's crimes have destroyed my family's and my life. Since not being involved in this case as much as I could, I am not aware of what the court knows. Do they truly know this evil man's true story? I am curious if they are aware of the real reasons he snapped that night. His cell phone taken from him due to an outrageous bill, cutting his communications with a girlfriend in a different state where they planned to be wed in a Nazi-themed ceremony. I wonder if you were all aware of his dark side and his demons he believed he could summon to hurt others, or of the violence he inflicted upon his siblings throughout our childhood. I truly feel the courts are in the dark on how deep his evil is rooted. I am here today to fill in those missing pieces to this story. In 2008, he brutally stole the life of our parents in front of me and my younger brother, Devin. That moment, like so many others during our childhood, was only one episode in a long history of violence and cruelty. Growing up with him was not merely difficult, it was a constant nightmare. We endured repeated physical beatings, relentless psychological abuse, and sexual abuse when he felt it was deserved. As if those things weren't enough, he would turn our parents against us by destroying or damaging things. For example, dumping every single item of clothing in the middle of our rooms and telling our parents that we did it because we hated them. He often created situations designed to turn the adults against us while protecting his own image. What frightened me the most was how quickly he could change his behavior when authority figures or adults were nearby. Moments after hurting or threatening us, he would instantly smile, act calm, kind, and completely harmless. A perfect angel. I remember him hurting us. And then the moment he heard an adult approaching, switching demeanor entirely while silently squeezing or pinching our arms as hard as he could as a warning to not say anything. That constant message that speaking up would lead to retaliation shaped my childhood and is a large part of why I have remained silent and fearful for so many years. We, as children, tried to get help. We told our elders. Throughout my childhood, my older brother used intimidation and threats of violence towards my younger brother, Devin, to influence what he reported to our parents and family. Because of this, my younger brother would deny my accounts and support my older brother's versions of events out of fear. Over time, this led to my parents believing that I was not credible, as my statements were consistently contradicted by both of them. This pattern reinforced a perception within my family that my older brother was reliable and truthful, and that he could not be questioned. As a result, he learned the needed behaviors and actions to become a master manipulator. He easily was able to put on an act with a face to match an angel. Because of my family's failure to see through this, the harm continued and deepened, leading to that horrible night. I begged to be believed. No one protected us in time. The consequences of his actions are with me every single day. After all these years, I have cycled through numerous therapists and a long list of medications trying to heal from what he did, yet to truly find something to help me. I live with complex PTSD, crippling nightmares, panic attacks that strike without warning, dissociation that makes me feel like I am not in my own life, and a persistent derealization that steals my sense of safety and reality. These conditions have wrecked my health, affected my family and relationships, undermined my work and previous schooling, and forced me into a life shaped around fear and survival instead of growth and joy. Forever, our family will suffer because of this man. Family who will never get to feel their love. Our parents will and have already missed major life events. They have missed their grandsons' births, our weddings, graduations, ceremonies. Their baby boy, my youngest brother Tristan, will never know their voices or mannerisms. Life forever changed because of this man. I am angry. I am angry for what he did, angry at the long shadow he cast over my childhood, and angry at a system that has failed to stop him sooner. But beyond anger, I am terrified. The thought of him being released haunts me. I do not want him near me, my family, or anyone else he may encounter in the public. One of the most painful parts of this process has been hearing the narrative simplified in ways that erase what I experienced directly at his hands for years. Part of why I have remained silent for so long was because attempts to speak out about the abuse and fear within my family were minimized or explained away. My own grandmother stands on my brother's side, even after I told her the whole truth as a child. Likely, this is why she did not allow me to testify as a minor, as well as why she and I have not gotten along. Her defense is despicable and in a dishonor to the truth, as well as a slight against my mother and her own son who loved her dearly. Even after disclosing what we experienced living with our older brother, the truth was dismissed rather than protected and brought to the court's attention. Her involvement with my older brother was one of many reasons why I left her home when I was only 16. Even after leaving their place of residence, her support was non-existent, pretending I did not exist, as she did with my mother countless times before, and even refused to support my continued education when I was in high school. The silence and disbelief of her actions follow me even now. I know the defense may focus heavily on my father's shortcomings and conflict within our household. So many stretched truths have been told over these years, it sickens me to hear these things about our father. Well, he was not perfect. He brought so many smiles to our family as well as anyone he encountered in the community. Many people have even come forward to tell us of the lasting positive impacts he left on their lives after his passing. To hear him being painted a terrible father or an abuser is sickening and a cheap excuse for my older brother's terrible actions. Yes, my family was not perfect, and there were unhealthy dynamics and discipline that affected all of us. I do not deny that. But I also need the court to understand that my brother's abusive behavior began long before the murders, and cannot simply be explained away as one emotional outburst. As far back as I can remember, I lived in fear of my older brother. The abuse, manipulation, intimidation, and harm I experienced from him were ongoing patterns of behavior that existed independently of any single argument or incident in the household. If anything, he was the favorite because he was never seen or caught doing wrong. Through the scapegoating and intimidation methods he practiced daily. I understand the courts may hear about his good behavior while incarcerated. I cannot say that behavior surprises me. In my experience growing up with him, he was able to present himself one way to authority figures and another way behind closed doors when he had us alone. One of the most terrifying aspects of living with him was that retaliation did not happen publicly. It happened privately when no one else was there to witness it, where he would whip us with belts. He would punch us. He used his little sister's body in any way he felt and screamed as loud as he could in our ears. He always made sure to get even. This is what created an environment of constant fear about speaking up or against him. Because of that, outward compliance alone does not make me feel safe, nor does it reassure me that the underlying danger is gone. I know his tricks. In many ways, his ability to appear controlled and cooperative to others was always part of what made him so difficult to protect ourselves from. He has shown a pattern of manipulation and control his entire life. His ability to charm and deceive is not rehabilitation. It is the same skill he used to harm us and evade accountability. If the court considers any reduction in his sentence or early release, I beg you to put the safety of victims and the community first. Do not be persuaded by polished behavior in custody. I am here to ask the court to recognize the full ongoing damage he has caused. This is not a past chapter that I can close. It is a wound that bleeds into every part of my life. I urge you to weigh that harm heavily in your decision. I am begging the courts to keep this man locked up, not only for my safety, but for my family and the public. I understand the courts may consider his good behavior while incarcerated as evidence of rehabilitation. I reiterate my urge for you to understand one of the most frightening aspects of his behavior was his ability to appear controlled, cooperative, and even kind to others while creating fear privately behind closed doors. The night our parents died, I truly believed I survived because I told him I would not speak against him and would lie to the police about his actions. This moment of fear for my life reflects the level of fear I lived under the extent to which I believed retaliation was possible if I went against him. Even now, as an adult with children of my own, the thought of his eventual release fills me with fear. That fear did not come from one isolated incident. It came from years of experiencing his terror firsthand. Please consider the absolute maximum sentencing possible for this man is an absolute nightmare when left unchecked. Do not allow his polished acts and words to fool you. He was less than 2 months away from being an adult when he killed my parents. He knew what he was doing. Please do not allow him to exploit this hole in the law. Thank you for hearing me today and for considering the real and lasting costs of his action. I am only alive today because I lied to him when he threatened my life that terrifying night. Please don't let this monster fool you with his good deeds and model citizen behavior. He is a true master manipulator who had our entire family fooled.
Thank you, Your Honor. As the court knows, I wrote a resentencing memorandum. I'm not gonna readdress things in there, but there are a couple of things that I wanna say for the record. One is, I believe it's worth noting that Mr. Sosby was originally sentenced on the second-degree murder convictions, one of the life sentence and one of 375 months to 750 months. It is because of the life sentence that we are here today. Again, as was indicated by Ms. Swain, we are here because of people of East Stovall, and this court's bound by that. But this court also has the ability to sentence Mr. Sosby to a lengthy term of years. There has been no parameters put on that term of years, except for obviously this court needs to and must consider youth as a mitigating factor when taking into account the snow factors and determining a proportionate sentence. That is not disputed. This court is in a very unique position, resentencing Mr. Sosby 17 years later. And again, I'm not going to reiterate the legal arguments and specific facts of this case. Mr. Sosby pled in this case, so in terms of a record, we are limited. I would urge the court to take Samantha Moore's statement and understand the complicated dynamics of this case and the selfish acts of Mr. Sosby and the significant detrimental impact it has had on this family, not only of Ms. Moore, but his siblings, his other siblings, Devin and Tristan, who have not provided impact statements, which is their prerogative. I would like to note that OB5 was scored at the maximum of 15 points. That is psychological injury sustained by a member of the victim's family. It absolutely does not adequately account for the psychological injury that Mr. Sosby has caused his siblings and his family. Just like this court can take into account Mr. Sosby's MDOC record, which I do not dispute, that he has taken advantage of the programs available to him and has seemingly on paper benefited from them. But this court should equally be able to take into account what's happened to the victims over the last 17 years. They would not, back in 2009, 2010, when he was originally sentenced, been able to do that in the way that they are able to do that today. There are multiple versions that have been presented today and in the past of what happened, not only on that night, that day, but what has happened in this family prior to that. But there's no doubt, and defendant himself has admitted that he premeditated the murder of his father. While he did plead a second-degree murder, that premeditation is not in dispute. There's we're never going to know why exactly Mr. Sosby chose to murder his mother that night. He has apologized for it. He has expressed remorse. However, It also appears that it's quite likely that he killed his mom so that she didn't turn him in. He attempted to convince Miss Moore to lie for him so that he could get away with it as well. Again, this court is in a unique position. It must consider Mr. Sosby's potential for reformation. But it is also appropriate for this court to consider the impact on the victims, the protection of society, punishment, and deterrence, all while taking into account youth as a mitigating factor. The OV total in this case is 260 points, which is more than twice the maximum 100 points. The guidelines are at 225 to 375 months on the second-degree murder convictions. And we are requesting that this court impose no less than 360 months on the minimum. In addition, I would ask this court to impose a no contact with Ms. Moore. And again, as this court knows, it must resentence on all the offenses. We are asking the court to reinstate the same sentences on the other offenses, but we are requesting 360 months on the minimum.
Sentencing in a case where lives have been lost is as difficult as it gets, and I always say that, but this is a particularly difficult situation given the nature of the crime, the nature of the circumstances, and the nature of the emotional devastation that has resulted from what occurred here. The United States Supreme Court in Miller versus Alabama decided that mandatory life sentences without the possibility of parole for crimes committed before the age of 18 were unconstitutional. They violate the Eighth Amendment's prohibition on cruel and unusual punishment. In doing so, the United States Supreme Court acknowledged that as a result of adolescent brain development, children have diminished culpability compared to adults and a greater capacity for rehabilitation. The Michigan Supreme Court in the 2022 case of People versus Stovall held that life sentences with parole for juvenile offenders violates the Michigan Constitution's prohibition against cruel or unusual punishments. Consistent with Stovall, Michigan Supreme Court entered an order in this case vacating Mr. Sosby's sentence as it included a parolable life sentence. Cases decided by the United States Supreme Court and the Michigan Supreme Court make one thing abundantly clear. And that's that youth matters in sentencing juvenile offenders. Michigan Supreme Court has established 4 basic sentencing considerations. Those are reformation of the offender, protection of society, disciplining the offender, and deterrence of others from committing like offenses. It goes without saying that the offenses here are among the most serious that we face in society. 2 murders, felony firearm, assault with a dangerous weapon, and interfering with a police investigation. I received a lot of information about this case, and I've had the opportunity to hear the attorneys make their arguments, hear Mr. Sosby make his statement, and hear Ms. Moore make her impact statement. And those things are difficult at this point, having just heard it, to reconcile. Obviously, Mr. Sosby had no prior criminal history before committing these offenses. But he did commit these horrendous offenses that devastated the family. The parents are both gone. Mr. Sosby has been in prison. His siblings were left without the adults in their immediate family and were raised by their grandparents. Emotional wounds caused by these crimes obviously have not fully healed. They likely never will. And as we just heard, are, at least in one case, wounds that are still very raw. Mr. Sosby was 17 years old when he committed these offenses, which include the murder of his parents. His family and home environment, as outlined in documentation that I have, were dysfunctional, and I would even say highly dysfunctional. Most significant characteristic of that environment in the record that's before the court is the physical and mental abuse that was occurring in the home. Started at a very young age, very early in life. And unfortunately, Mr. Sosby's mother was unable to protect him. And for years, he didn't have any viable means of escape due to his youth. Research suggests that juvenile offenders have a greater capacity for rehabilitation. And again, based on the record that is before the court, that appears to be on display with Mr. Sosby. While in the custody of the Michigan Department of Corrections, Mr. Sosby has taken steps to get an education, to address the issues that he faces as a result of his difficult childhood and the crimes that he's committed, and to help others take steps toward rehabilitation themselves. His record while in custody includes only one significant infraction over a long period of time. It's extremely low when measured against the typical rate at which inmates accrue infractions. Based on the report of Richard Stapleton that was attached to defendant's brief, stands in particular contrast to the fact that younger offenders are more likely to have a higher number of infractions while incarcerated. There's been an argument or a statement here today that that behavior is part of manipulation by Mr. Sosby to look good or minimize what's happened here. But I would note that the length of time that this behavior has gone on and the setting in which it has gone on suggests that it is something real and substantive as opposed to the manipulation. And so it is a very difficult job to try to reconcile, again, the crimes that have been committed and the devastation that results from those crimes on one side of the scale, and on the other side of the scale, Mr. Sosby's really exemplary record while he has been incarcerated. He has done everything that society asks a person to do in that situation. And it would appear at this point, based on all of that, that he is at a low risk to reoffend. It would appear that he has been significantly reformed during his time. And that given the decreased likelihood of his reoffending, that society would be protected by a lower sentence than what was originally imposed. With the understanding that sentencing for juvenile crimes, the focus shifts away from discipline and deterrence and toward rehabilitation and reformation. I don't believe that the discipline of the offender and the deterrence of the offender and others is completely removed. And I do believe it is still consideration. And it must be here based on the nature of the crimes. And so today is an attempt to balance two things that in some ways feel impossible to balance. Ultimately, I come back to what I said at the beginning, is clear from the decisions of this US Supreme Court and the Michigan Supreme Court as it relates to juvenile sentencing, and that is that youth matters. And those factors must be considered and are considered here today. With respect to the interfering with police investigation, sent to the court that Mr. Sosby served 57 to 120 months with the Michigan Department of Corrections. With respect to the assault with a dangerous weapon charge, it's the sense of the court that Mr. Sosby served 23 months to 48 months with the Michigan Department of Corrections. With respect to both of the second-degree murder charges, it is the sense of the court that Mr. Sosby served 260 months to 750 months with the Michigan Department of Corrections. And with respect to the felony firearm, it is the sense of the court that Mr. Sosby served 24 Department of Corrections. By law, felony firearm has to be served first, and the other charges are consecutive to the felony firearm charge. Ms. Holly, do you have the credit on? Keep finding it quickly.
From 9/24 to 08, 9/24/08 to 5/14/26, it's 6,441 days. Any of that credit would go toward the felony firearm first.
6,000.
441 days.
So we will have to do the math on that, but it's 6,441 days total. The first amount is applied toward the 24 months of the felony firearm, and the balance is applied toward the remaining charges, which are concurrent.
I don't know if crime victims' rights fee and state costs stay the same. Crime victims' rights fee since 2010 has gone up to 130. He was ordered 60. I don't know if that would change. State costs are the same.
I will impose the same costs that were assessed at the first sentencing. I believe that's appropriate given time. Mr. Sosby, the bailiff is going to hand to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. Need to sign the top copy of that form, and indicates that you received your copies of those forms. Return that to the bailiff. If you want to request an appeal of your sentence and have an attorney appointed for you to do that, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes.
Did you want to add a no contact?
Thank you. We'll add a no contact provision that Mr. Sosby not have contact with Samantha Moore. The record should reflect that. I do have a copy of the signed appellate rights form from Mr. Sosby and placing that in the file. Is there anything else that needs to be addressed today?
No, Your Honor, thank you. Nothing from defense.
All right, thank you for your time. Sir, Fry, you ready to proceed with Mr. Scivoletto?
Yes, Your Honor.
This file 25 dash. This is file 25-22237-FH, People of State of Michigan versus Jonathan Paul Scivoletto. We are here today for sentencing, but there's also a motion to withdraw a guilty plea. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Morning, Your Honor. Brian Fry, attorney for Jonathan Scivoletto.
Mr. Fry, you have filed a motion requesting to withdraw Mr. Scivoletto's plea. You can proceed with any arguments you'd like to make about that.
Yes, Your Honor. We did file a motion to withdraw the guilty plea in this case. After many discussions with my client, after I took over this case, he maintained the whole time that is what he wished in this case. He maintained that when he entered the plea, as I noted in my brief and motion, that he was dealing with some mental health issues related to some severe depression and anxiety. He was indicated that his attorney at that time told him that he had to take the plea, he would have no chance at trial. So at that point in time, he felt that he had to follow that advice, even though he wasn't able to think clearly. Following that, he was able to get on medication, which has allowed him to think clearly and realize that he had never wanted to take the plea in the first place or enter the plea, and only did so based on that pressure and that misunderstanding of his options. He is on his medication now. He is able to understand what he is doing. I would note that his attorney at the time had a conflict with this case, that they didn't remove themselves until after the plea was entered, and that occurred right after that. It should have happened before that ever happened, before the plea was entered, and he could have had some discussions without that conflict in place, with his representation. He is disabled, which prevents him from having an income. Impossibility is a defense in these cases. His disability, does form the basis for argument of that defense. When we look at the case law that as I cited in my brief, withdrawal after acceptance of the plea but before sentence is governed by MCR 6.310B, which indicates that the plea may be withdrawn on motion if it's in the interest of justice, unless it substantially prejudiced the prosecutor. There's no indication in this case that withdrawal of the plea would prejudice the prosecutor in any way. The case could proceed just the same. No evidence has been lost or witnesses lost or anything like that that would normally indicate that. So we turn to whether withdrawal of the plea would be in the interest of justice. If we look at the case law surrounding that, specifically some of the recent cases regarding that, if we look at People v. Bailey or People v. Fonville, as I cited in my brief, interest of justice in this case is defined as a fair and just reason for withdrawing the plea. And to show that, my client would have to show that he has a fair and just reason, and that those reasons are a claim of innocence, a valid defense, or something along those lines. Obviously, he has presented a valid defense to the charge in this case of impossibility, which would support withdrawing the plea. He's also presented fair and just reasons regarding, his understanding, his mental health issues at the time of the plea, his lack of medication, and the issues surrounding his counsel. Further, I would note that he, on his own, I'm not involved in his child support civil case, but he has filed motions regarding that are pending. My understanding is that friend of the court ruled on some, but not all. The child support was reduced by $800 a month to $400 now. But the rest of his motions dealing with some underlying issues that could, in my client's opinion, potentially eliminate, arrearages, hasn't been dealt with, and that would, it's gonna have to be dealt by this court at some point in the future. So those are still also pending, which could be another defense for my client if there's no arrearages left of those motions. So, Your Honor, I think the case law and statutory court rule authority in this case does support a withdrawal of the plea. We would ask that the court to allow my client to withdraw his plea today. Thank you.
Ms. Brenner.
Your Honor, I don't believe that there's been adequate showing that there was a medical issue going on at the time of the plea. Just his statement that he had an issue, I don't believe is enough. We should have some medical documentation about what his status, if that's what his claim is. I don't think that there's any showing that he was entered his plea involuntarily or under duress. Additionally, the defenses that he states are not actually defenses. Those would be inability to pay defenses, not impossibility to pay. What it sounds like here is that he wants to wager an impermissible collateral attack on the underlying order, which he cannot do based on People versus Iannucci. If he has difficulty making his payments, then he has to avail himself to the civil process and make motions to modify. Or if he's got health conditions that are precluding him from paying, then he makes a motion with the friend of the court. Those are not things that would be allowed at a trial. So that's not a valid defense that he's presenting at this time. Even if his balance changes, that still is not going to affect the fact that he didn't pay anything during those time periods. So I don't believe that he is asserting a valid defense. We could have an impossibility hearing if that is something that we go forward with, but I do not believe that he's presented enough evidence to show that he entered this plea unknowingly, involuntarily, or under any duress at this time. So I would ask that you deny his request today.
Mr. Fry, care for any rebuttal?
Your Honor, obviously, my client had entered this plea. It was verified by him, declaring his statements were true to the best of his information, knowledge, and belief. I believe that verified statement is what would be required. If the court wanted more evidence than that, then the recourse would be to schedule an evidentiary hearing on that issue. There are medical documentation we could produce, so my client is obviously not wanting to attach medical documents to a public motion, as that would be best be handled in camera versus a public filing. And also, impossibility is a defense that a jury could hear in this case, Your Honor. And obviously, I cited the case law regarding that. Thank you.
All right. Well, I would note that during the plea, Mr. Scivoletto also testified to the court that he was not that he fully understood, voluntarily accepted the plea. And so at this point, the only thing the court has is his statement now that he didn't do that. And so if you would like an evidentiary hearing on the issue of his medical status at the time of the plea was entered, I will grant you that, but I don't think it's sufficient to simply rely on the statement Mr. Scivoletto at this point, because he's now testified both ways.
We'd request an evidentiary hearing, Your Honor.
All right, I will ask then you, Mr. Fry and Ms. Brenner, to get in touch with Francis and get that scheduled.
Thank you.
It's both of them up now.
Yes, ma'am.
Okay.
Is that all you're
Great. Thank you, Your Honor. So are you reserving judgment on this motion, or do you want him to refile it after the evidentiary hearing? Just so that the record's clear, you're not denying or confirming.
Right. I'm making no decision at this point. I'll make a decision after we've had the evidentiary hearing.
Yes, Your Honor. Thank you.
All right, ma'am, you are Ms. Keller.
Thanks, sir.
Technically, sir, my name is Rhodes, but yes, I was Mrs. Keller.
Okay,
That's all I had, Judge.
thank you, Ms. Holland. All right, this is file 24-51453. I'm sorry, 51453-UN. Christian Jacob Beck versus Annette Darlene Keller, who is now known as Arnett Darlene Rhodes. So, ma'am, you are Arnett Darlene Rhodes.
Yes, sir.
Have you received a copy of your warrant?
No, sir, I have not received anything. In fact, I'm a little confused.
Okay. I don't want you to say anything else right now. I've got to ask you some questions to make sure that you understand what your rights are before you say anything.
Yes, sir.
We will send a copy of this warrant over to the jail to have it brought to you.
Yes, sir.
I will let you know that the warrant alleges that you failed to appear for a court hearing on December 15, 2025. That court hearing was a hearing on an order to show cause that allege that you failed to pay child support to the best of your ability up to the amount ordered. According to the information I have from the friend of the court, you do not currently have a monthly child support charge, but you do have an arrearage in the amount of $53,091.65. Do you understand, Ms. Rhodes, that it's a crime to fail to appear in court when you've been ordered to appear?
Yes, sir.
Do you understand that it's a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes, sir.
You understand that if you were to plead guilty or be found guilty of either of those offenses, that the court could sentence you to jail for up to 30 days?
Yes, sir.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
You are entitled to be represented by an attorney today and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that, and I'll appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
I don't know, sir, because there's other issues involved.
Okay, that I understand there may be other issues, but I need to know before you say anything, because if you say something and it harms your position or somehow unknowingly admits your guilt, then that can be used against you. So before you do that, I need to know whether you want to talk to an attorney.
Yes, please.
Okay, do you have the ability to pay for your own attorney?
No, sir.
Okay, I will appoint the public defender's office to represent you, and I'm going to put you in a breakout session right now with Ms.
Yes,
Underwood from the public defender's office.
Okay, thank you, sir. Here's this. Thank you, ma'am.
Sam, could you shut my door, please? Thank you.
All right, Mr. David, are you ready to proceed with Mr. Welch?
Yes.
This is file 26-22533-FH, People of the State of Michigan versus Isaiah Matthew Welch. We are here today for sentencing in this case, and we are proceeding today in person. Mr. Dagger. Oh, I'm sorry. Let's see, Ms. McClure, are you appearing on this one?
Yes, Your Honor.
All right, go ahead and state your appearance, please.
B.B. McClure, on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Welch.
Yeah, and sir, you are Isaiah Matthew Welch?
Yes, sir.
Mr. Welch, have you had an opportunity to read and review your pre-sentence report?
Yes, sir.
You had an opportunity to discuss that report with Mr. Dagger Margosian?
I discussed it this morning a little bit. I found 10 errors contained within it.
Okay, all I want to know right now is if you're satisfied with the opportunity that you've had to discuss it with Mr. Dagger Margosian.
Yes.
What are the errors that you, or Mr. Dagger Margosian, are you going to address those?
Your Honor, I'm going to have Mr. Welch do them. They are ministerial in nature, so I'm going to have Mr. Welch address them.
Okay, what are those then, Mr. Welch?
On the first page, under personal history, it is stated that I quote unquote have a substance abuse history. Correction is, I have never had a substance abuse history, nor have I ever been treated for any substance abuse my entire adult life. I stated to Officer Teskey of the probation department that I have, as many adults do, drank alcohol in my adult life. I've never been a heavy drinker, as I have a history of alcoholism from a genetic perspective, and as I have several relatives, including my biological father, who are alcoholics in my genetic history. Thus, it has been a personal choice that I would never let alcohol be a controlling factor in my life, no matter how difficult my life has been. The second error is.
Wait, slow down. Ms. Teskey, what is the information you have that is the basis for the substance abuse history?
Your Honor, that's what he reported to me during the PSI interview. Hang on, Judge, I'm getting to that page. That is what he reported during the PSI interview. It's what I wrote down.
Your Honor, I think on page 6, it indicates that he denies substance abuse history, so I would stipulate to changing that to no on the first page.
All right, if people are willing to stipulate, then I will change that to no on the base sheet. What is the next issue, Mr. Welch?
Third page, under quote unquote evaluation plan, it is stated that I was quote discharged from the US Navy for mental health conditions in 2003. The correction is this is false, as my form DD 214 states, per my discharge reasons, that my discharge was for quote convenience of the government, not a physical or mental disability. Unquote.
Your Honor, would you like me to speak or no?
Yeah, go ahead.
I have a copy of the DD 214 and it indicates physical or mental health conditions.
I'm sorry, your audio was broken up. Can you?
I said I have a copy of the DD 214 and it indicates physical or mental health conditions.
Can you bring that over to the courtroom?
I will. You're right there, Judge.
Thank you. All right, I have just been handed a copy of the certificate of release or discharge from active duty. 28 at the bottom of that form. For the heading narrative reason for separation indicates convenience of the government, physical or mental condition, parent, not a disability, close parent. I think that is consistent with what is written in the evaluation plan, so I would not make any change. what is your next issue, Mr. Welch?
On number three, the third one is the third page under evaluation plan. It is stated that, quote, when his mental health is not being adequately addressed, he is clearly a danger to society. Correction is, at no point in my adult life have I ever posed a danger to myself or others. While I have a misdemeanor conviction in Illinois from 2014, that charge of conviction stemmed from a physical altercation whereby my ex-fiance, with whom I had been dating for the previous 4.5 years, had physically attacked me without provocation, thus forcing me to have to defend myself. The current case was the result of several factors, the least of which was the fact that I was sleep deprived and had not been able to gain enough sleep in the previous 36 hours necessary to enter an REM cycle. I had worked the previous day for 13.5 hours, and despite telling both my mother and my sister that I needed my sleep, was still not rested when the confrontation between myself and my brother occurred on 30 October 2025.
Ms. McClure, is there anything you want to say about that issue?
Just from my intimate knowledge of the case and what went into the resolution of this case, I just think on its face, a person who, although maybe sleep deprived, turns to violence such as this, probably does have some unaddressed mental health issues. So I think it's appropriate that that stay in there, just for the accuracy of this. There's a lot of people that are sleep deprived that don't necessarily turn to violence of this nature.
I would note that in this case, I understand the position that you're taking now, Mr. Welch, but you have pled guilty to assault with a dangerous weapon or felonious assault. And I do think that that supports the statement in the evaluation and plan that you are challenging, so I would not make any change to that. What is your next issue?
Number four, third page under evaluation and plan, it is stated that, quote, that caused him to attend several different schools before quitting, unquote. Correction, this is false. Only once did I ever change schools as a direct result of bullying in school. This occurred in 1997 when I moved from Adrian Public Schools, having attended Springbrook Middle School the previous year, to St. Creek Schools. This occurred because I had been bullied at Springbrook, and despite parental intervention by my mother, the school administration refused to do anything about the bullying. Thus, I moved to St. Creek in the fall of 1998 for my 8th grade year. Additionally, I did not quit school. I graduated in 2002, thanks to the help of my United States Navy recruiter, who helped me to find a parochial school, Westland Christian Academy in Westland, Michigan, so that I could begin my military service in October of 2002. Officer Teskey knew this when she submitted the pre-sentence investigation report, as I presented her with both my high school diploma as well as my form DD-214 for my military service.
All right, Ms. McClure, anything you want to say on that one?
I would defer to Ms. Teskey. I don't have anything.
Your Honor, he reported to me that he quit attending school. Yes, he did go back and obtain his high school diploma, and I've notated that in the report, but he did quit conventional high school. And that is what I've stated in this report.
So, Mr. Welch, you quit at one time and then went back and got your diploma?
No, sir, I had never quit school. I was actually in my senior year of high school after my class had graduated, as I had been told by St. Creek High School that I would have had to go back for one more semester as a 5th year senior to graduate. While I was doing that in late May of that year, because I was in contact with my recruiter, he had said that he was going to find me a way to try to graduate before then. I was in school for approximately a week and a half, thus 10 days, I think. And on day 10, he came into St. Creek High School and let me know that he had found a parochial school for me to attend. And he said that at that school, I could get the credit and a half I needed to graduate.
I'm going to change that sentence so that it reads, he was bullied in school and that caused him to change schools, period. And in a new sentence, he attended several schools before graduating. All right, Mr. Welch, what is your next issue?
7th page in the family narrative. It is stated that his mother had a child from a previous relationship before he was born. The correction is, this is false, as I am the firstborn child of my mother, Juanita Davis. I believe Officer Teskey confused my mother for my stepfather. My stepfather, Jerry Davis, who has since passed. He had 4 children from a previous marriage that he had had.
Ms. Teskey, anything you want to say on that one?
I'm not opposed to just deleting the sentence that states, he states his mother had a child from a previous relationship when he was born.
All right, we will just delete that sentence. What is your next issue, Mr. Welch?
The next 2 issues, Your Honor, have been since corrected. The next issue would be 8th page under vocational other training. It is stated that no vocational other training information found for the defendant, unquote. The correction there is I have had other vocational training in the past. From October 2006 to February 2008, I attended Cincinnati Job Corps Center in Cincinnati, Ohio, where I received an automotive ASC certification for brakes. I still have the certificate in my possession and was not asked to present it to Officer Teskey during my interview with her.
So I will supplement the report with that additional information. If you didn't give it to her previously, I think the statement in there can remain because she didn't find any. But
I have the certificate. I can never make.
I understand that, which is why I said we can supplement it to include the additional information, but it's not a reason to take out the statement.
Even though it says there's none.
Because both things can be true. She didn't find anything, and you today are presenting it for the first time.
Okay, I understand.
What is your next issue?
9th page under liabilities, it is stated that I have a $50 per month liability for rent at my apartment. The following happened in between my interview with her and today, which is that in March of 2026, Mishta, who pays a portion of my rent via Section 8, increased my rent from $50 a month to $443 a month, effective on the 1st of May, 2026.
All right, so again, we can supplement the report with that additional information about the increase in your rent. But again, it was true as of the date she prepared the report. So we're not going to take the statement out, but we'll include the additional information. What is your next issue?
The last issue I have, Your Honor, is on 11th page under basic information report. It is stated that I have no driver's license. The correction is I have a Michigan driver's license. The driver's license number is.
I don't want your driver's license number on the record because someone might see that or hear that someday. Do you have a copy? Do you have your license with you?
Yes, sir, I do.
Right, so I have been handed what appears to be a valid Michigan driver's license, doesn't expire till 2029, so we will change that statement to reflect that he has a driver's license. Did you say that was your last?
Yes.
All right, Mr. Dagan-Margosian, the probation officers calculated the minimum sentencing guidelines to be 0 to 17 months. Do you agree with that computation?
No challenges at this time.
Ms. McClure, do the people agree with that computation?
Yes, Your Honor.
Does the pre-sentence report, Mr. Dagan-Margosian, disclose any prior convictions in which there exist any known constitutional defects?
None to my knowledge at this time.
Ms. McClure?
No, Your Honor.
All right. Before the court passes sentence, then, Mr. Dagan-Margosian, is there anything you want to say on behalf of Mr. Well?
Your Honor, I would just ask the court to follow the recommendation. I think it's appropriate in this matter for a term of probation as well as suspended jail. Mr. Welch obviously is very, very invested in this process, and it's not going to be a problem for probation or for this court. We're simply asking the court to follow the recommendation.
Mr. Welch, is there anything you'd like to say on your own behalf before the court passes sentence?
I thought about what happened the night that me and my brother got into it a lot since it happened. Even when I was dealing with the legal process and speaking with various members of my family that I could speak to. I was concerned for my brother's health. I was concerned for his recovery, even though I couldn't speak to him personally. And even since that night, I've only spoken to him once or been in his presence one time, and that was for Easter after he modified the order. I regret deeply to the core fundamental fiber of my being what happened that night. And honestly, I wish I could have, I wish I would have just walked away. And it was a lapse of judgment I've never had before. And to be honest with you, it scared me as the person who experienced what happened and everything that went into it and the situation and the context. I thought back on it later, and I don't know if a person could ever be scared of themselves, but knowing that, it scared me. And to this day, me and my brother, we did actually reconcile on Easter. We had a short conversation, and he did forgive me. And I did actually ask him for his forgiveness. So him and I, as far as I can tell at this moment, despite what happened, we have reconciled and are on somewhat even footing. So.
Thank you. Ms. McClure, do the people wish to be heard?
Very briefly, Your Honor. Mr. Davis is not here today. He works nights and sleeps during the day. And I just had brief conversations with him about the direction of this case and what would happen with Mr. Welch. And Mr. Dagger-Margosi and Mr. Welch were more or less privy to those conversations as well, which is how we came to this resolution, which I do stand by. I think Mr. Welch is remorseful and regretful. I worry a little bit that there's not accountability. Just I kind of hear that in the themes of Mr. Welch talking. Even though does seem remorseful, I worry he's not quite accountable for this fairly insignificant triggering event that caused something really dangerous to happen. But at the end of the day, Mr. Davis, his brother, did not want him to be subjected to jail or prison. He wanted to distance himself from his brother and the case, but while also leaving the door open to make amends, which it sounds like they did do. But he does want him to, or he believed he should engage in some form of anger management, or in hearing some of the things today, maybe a mental health evaluation. I know term 2 is asking for a psychological evaluation if referred by the field agent. So something along those lines, something to better himself while on probation, instead of just a kind of empty probation term. I know the recommendations for 9 months in jail with credit for 1 day served. The people would ask that the court not order that and instead follow the sentence agreement that was made. Otherwise, the people would leave it to the court. Thank you.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of probation department, as well as what's been said on the record this morning. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and protection of society. Mr. Welch is 43 years old. He does not have any prior felony convictions. He does have 2 prior misdemeanor convictions. He has pled guilty in this case to 1 count of assault with a dangerous weapon. There is a sentencing agreement that there be no initial jail sentence. Case having heard both sides' positions, I do think that imposition of a sentence consistent with the plea and sentence agreement is appropriate, and so it will be the sentence of the court, Mr. Welch, that you serve a period of probation for 2 years, subject to the following conditions. You must take medication as prescribed to you by your licensed physician. You must complete a psychological evaluation when you are referred by your field agent. You must obey all court orders. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not use any object as a weapon. You must not own, use, or have under your control or area of control any type or imitation of a weapon. And you must not be in the company of anyone that you know to possess those items. Must allow your field agent into your residence at any time for probation supervision. You must submit to a search of your person and property, including but not limited to vehicle, residence, and computer, without need of a warrant if the field agent has reasonable cause to believe that you have items which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to your field agent within 24 hours, weekends and holidays accepted. You must pay a crime victims assessment in the amount of $130, a supervision fee in the amount of $30. That would get increased to $60 per month if electronic monitoring is required. Pay $750 court costs, a $60 DNA fee, and a $68 state cost. The bailiff is going to hand to you, Mr. Welch, 3 copies of the notice of right to appellate review and request for appointment of attorney form. You need to sign the top copy of that, return it to the bailiff. That just means you got your copies of those forms.
Would the court consider adding a term ordering anger management counseling through Sally Welch or some other organization?
I'm going to leave that at this point to the probation officer, and we will see how the probation proceeds forward. If that, based on if there's a psychological evaluation, if there's a necessity for that, I would the probation to include that, but I am not. Let's hold off for the moment on doing that.
Okay.
Records should reflect I do have a copy of the appellate rights form signed by Mr. Welch, and I'm placing that in the file. Mr. Welch, if you want to request an appeal of your sentence or conviction and have an attorney appointed for you to do that, you would need to fill out the remainder of that form and mail it to the address listed in the form within 42 days. Or if you know that you want to do that now, you can fill it out now and take it back from me right now.
I'm sorry,
What's that?
I didn't catch the last part.
If you know now that you want to fill that out and request an appeal, you can fill it out now and we'll take it back from you today.
Oh.
You understand that?
Yes.
Okay. So you are all set. Ms. Teskey, when do you need him to report to you?
Yeah, Tuesday morning at 8 a.m. Isaiah.
Your Honor, the only other issue that I told Ms. Welch that I would address is his cell phone had been confiscated in the investigation. I spoke with the trooper. They said that they would return it. They don't need it anymore. We've been getting the runaround. I told Mr. Welch that I would address it with the court. I don't know if there's any guidance that the court can give us as far as if there needs to be an order presented for a claim and delivery, but we continue to get the runaround on the release of this item.
So there's a
personal.
There's a method for obtaining property back from the police that's been seized in an investigation. I can't just simply order it today because you're requesting it.
I understand.
Follow that process.
Fine, we have been, so we'll continue to follow up with MSP.
All right. Okay, you are all set for today then, Mr. Welch. And Ms. Teskey, if you would like this back for your file.
Oh, yeah. Thanks.
All right. You for Teskey and Garcia.
Am I gonna zoom for Garcia?
Okay. They wanted to speak with you, Judge.
Carlos Garcia, Judge, please. You're not. No, the judge hasn't brought it back from the breakout room yet. He has a very, very busy docket this morning, so. Yes. Yes. Thank you. Bye.
Sarah?
Gotta mute it. Not yet.
Not yet.
He's calling him. He's gonna call him, no, I was just in the courtroom and he said he was gonna call him.
You're gonna call who?
Garcia, next,
Oh, you talked to him?
the judge, yeah,
You thought about
I went over there.
it.
Sarah?
Sarah, oh, never mind. Yes, never mind, I was gonna tell you weren't muted, but you are now. I don't know, I thought I muted myself and then I must have unmuted myself, I don't know. When they all walked into my office, I thought I muted myself, I must have unmuted it. Great. Yeah. Hi.
Yes.
All right, bye, Rhonda.
Bye.
Okay, Ms. Underwood, do you need to speak to Mr. Garcia?
I don't believe I do, Your Honor.
All right, we have to finish up Ms. Keller first, so let's do that, Ms. Rhodes. Okay, we are back on the record in file 24-51453-UN, Christian Jacob Beck versus Annette Darlene Keller. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Ms. Rhodes this morning, Your Honor. AKA
You know
Ms.
how,
Keller.
you know how Ms. Rhodes would like to proceed today?
I would ask the court to enter a not guilty plea on her behalf, Your Honor. It's my understanding this is a matter from Ohio, and she does have some documentation that says the matter was discharged. So I would like to research that. Ms. Rhodes was in Hillsdale because she was receiving medical treatment on her leg, Your Honor. I don't believe she's a danger to flee anywhere. This is a arrearage only matter. I realize it's a very large one. I would ask the court to enter a not guilty plea and set this matter for a hearing, perhaps on a Monday, and we can explore where Ms. Rhodes is at that time with a PR bond and perhaps telephone reporting or reporting to Mr. Coast, maybe.
All right, I will enter a not guilty plea. I'm sorry, is she able to start making any kind of payments at this point? Where are we with that?
I don't believe she can make a payment yet, Your Honor. I believe she can try to get back and get some money together. She doesn't have much. She, you know, she was living in a homeless camp.
All right, I'll set this for a hearing on June 1st at 8 a.m. I will issue a PR bond for Ms. Rhodes at this time. Ms. Rhodes, when you get released, you need to come directly over to the front of the court office and provide Ms. Senkowitz with all of your contact information.
Yes.
All right, you can let the officer with you know that you're done with court for today.
Thank you, sir.
Rhonda, I'll reach out to you later today about this case and let you know what I've got, okay?
Okay.
All right.
Thank you.
Thank you.
I appreciate that a lot.
Not a problem. Thank you, Your Honor.
Thank you, Ms. Senkowitz.
Yes, sir.
Mr. Valero, do you need to speak to Ms. Woolley?
I do not, Your Honor. I am good to go.
All right. This is file 24-21981-FH and 26-22596-FH, People versus Tessa Renee Woolley. We are here today for sentencing in these cases, and we're proceeding today by video conference. First, Mr. Malero, would you like to place your appearance on the record?
Salvatore Malero on behalf of Tessa Woolley.
And Ms., you are Tessa Renee Woolley, correct?
Yes, Your Honor.
Ms. Woolley, have you had an opportunity to read and review your pre-sentence report in the 26 case and the probation violation recommendation report in the 24 case?
Yes, Your Honor.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any information that's in either of those reports?
No, Your Honor.
Mr. Malero, any additions, corrections, or deletions to the pre-sentence report?
No, Judge, there are no corrections or deletions.
Does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects, Mr. Malero?
Not to my knowledge, Judge.
The probation officers calculated the minimum sentencing guidelines in the 26 case to be 0 to 17 months on the furnishing contraband charge. Do you agree with that computation?
Yes, I do.
And they're calculated at 10 to 23 months on the tampering with evidence charge. Do you agree with that computation?
I do, Judge.
Before the court passes sentence, is there anything, Mr. Malero, you'd like to say on behalf of Ms. Woolley?
Yes, Judge. I have represented Miss Woolley in the past. She's I think 51 years old now. She has a history of substance abuse. I think pretty much all of her legal troubles stem from that. I think that gets connected to some family members, and she has a difficult time separating the fact that she has to be good for herself before she can be good for others in her familial orbit. And she lets that influence the decisions she makes, which leads her to be in front of the court today. I think the recommendation, both for the violation and for the underlying charge, is appropriate. We'd ask the court to follow that. I would also ask the court to perhaps consider that Miss Woolley might benefit from some form of counseling when it comes to dealing with family members or the outside influences that cause her to make these poor decisions. That would be our request, Judge. I think there's also a contempt issue. I'd ask the court to merge whatever the contempt is into the sentence so that she does not have to incur any additional jail time. That would be our request, Your Honor.
Ms. Woolley, is there anything you'd like to say on your own behalf before the court passes sentence?
No, Your Honor.
All right, in determining the appropriate sentences in these cases, the court has considered the seriousness of your offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Ms. Woolley is 50 years old, convicted in the new case of furnishing contraband to prisoners and tampering with evidence. 24 case. It is a violation of probation resulting from the same conduct, and the underlying charge there is controlled substance possession of cocaine less than 25 grams. There is an obvious substance use history in this case that needs to be addressed. I will say that I have found this situation to be particularly frustrating with Ms. Woolley due to the interactions the court has had and up to and including when she was arrested on probation violation warrant, being told that how well things had been going and how great things were, and at that point apparently had the drugs on her as she was going into the jail on that warrant. And so it's a really frustrating position to be in, having given you, Ms. Woolley, chances and opportunities to address these problems, and having take those opportunities and making use of them, and rather, taking drugs into the jail and giving them to other people and causing more problems. Initially picked up the file, I was really inclined just to look at this and say, well, maybe MDOC is the right place for this situation, because we're having trouble managing Ms. Woolley probation from a probation standpoint. So that's kind of where my head is on these. I recognize that probation officer's recommendation is for some jail time and continued probation. And I do acknowledge that substance use problems are stop and start, and people have relapses. And so based on that, I'm willing to go with the recommended sentence as opposed to MDOC at this point. But you need to understand, Ms. Woolley, that you're running out of chances.
Yes, Your Honor.
So, you don't take advantage of this one, it's probably your last one in terms of what the sentences are going to be from this court if it's
I should
yours.
be better. I'm going to be better.
Will be the sense of the court that you, with respect to the 26 file, that you served period of probation for 2 years. Subject to the following conditions: you must not violate any criminal law of any unit of government, you must not leave the state without the consent of the court, you must not use or possess alcoholic beverages or other intoxicants, you must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on the site unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by our field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures, and you must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician, or be with anyone that you know to possess those items. You must use prescription drugs only as prescribed to you by your licensed physician. You must complete outpatient or residential substance abuse treatment when you're referred by your field agent. You must complete a substance abuse assessment when you're referred by your field agent. You must make a truthful report to your probation officer monthly or as often as your probation officer may require, either in person or in writing, as directed by your probation officer. You must notify the probation officer immediately of any change of address or employment status. You must obey all court orders. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have verbal, written, electronic, or physical contact with anyone that you know is housed in an MDOC facility without the permission of your field agent. You must not have verbal, written, electronic, or physical contact with anyone that you know to be engaged in any behavior which constitutes a violation of any criminal law of any unit of government. You must not use any object as a weapon. You must not own, use, or have under your control or area of control any type or imitation of a weapon, and you must not be in the presence of anyone that you know to possess those items. You must contact your field agent no later than the first business day following your placement on probation or release from jail. You must comply with the written or verbal orders made by your field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person and property, including with, but not limited to, your vehicle, residence, and computer without need of a warrant if your field agent has reasonable cause to believe that you have items which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to your field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week unless you are engaged in an alternative program approved by your field agent. You must provide ongoing verification of your employment or alternative program to your field agent, and you shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the agent. You must serve jail time of 142 days with credit for 82 days served. You must pay a crime victims assessment amount of $130, $30 per month supervision fee. That gets increased to $60 per month if electronic monitoring is ordered. I'm not ordering that now. You must pay a $750 court cost, a $60 DNA fee, and $136 state cost. I'm also going to include the provision that you participate in a psychological evaluation if you are directed by your field agent. With respect
Judge,
to,
I'm
sorry.
sorry. Did you want to release her early to treatment?
At this point, I will say she can be released after she has served 100 days to a residential inpatient treatment facility. With respect to the 24 file, sends the report that Ms. Woolley served 60 days in Lenawee County Jail. She has additional credit for 64 days served on that file. You have the ability, Ms. Woolley, to request an appeal of your conviction and sentence. We're going to send to you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those, there's a set of 3 for each file. When you get those, you need to sign 1 for each file and return that signed copy to us. If you want to request an appeal of your conviction or sentence and have an attorney appointed for you to help you with that, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, Your Honor.
Your Honor,
right.
for clarification, on the violation of probation, does she have to serve the 60 days? Can she be released early for treatment there as well?
Yeah, she's already got more credit than what was assessed, so she shouldn't have anything further on that.
And then we have a contempt issue.
Contempt. So on the contempt, All right, she hasn't pled on that, based on the sentences that the court has given and the fact that I would not do anything with a sentence on the contempt that would add any jail time. I'm just going to dismiss the contempt.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Ms. Woolley, you'll need to sign a release when you get to treatment and then, of course, report to me as soon as you're released from treatment, okay?
Even if I go into transitional housing, I just tell you if I go to transitional housing from treatment.
No, you'll need to report to me.
Okay.
Thank you, Judge.
All right, Ms. Woolley, you can let the officer with you know that you are done with court.
All right, have a good day. Thank you.
Ms. Underwood, are you ready to proceed with Mr. Garcia?
Yes, thank you, Your Honor.
Everybody out here?
Yes. All right, this is file 21-20575-FC. And file 25-22233-FH, People versus Ricardo Anthony Garcia II. We are here today for sentencing on a probation violation, and we are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Garcia this morning.
And sir, you're Ricardo Anthony Garcia II?
Yes, Your Honor.
Mr. Garcia, this is a sentencing in a felony case. As a result that you have a right to be present in person in the courtroom for the sentencing hearing. I would only proceed today by video conference if you want to waive your right to be in person.
Yes, I'll waive my right.
All right. Have you had an opportunity to read and review your probation violation recommendation report?
Yes, Your Honor.
Have you had an opportunity to discuss that report with Ms. Underwood?
Yes, I have.
Are you satisfied with Ms. Underwood and the advice that she has given you?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any information that is in the report?
No, Your Honor.
Ms. Underwood, are you aware of any additions, corrections, or deletions to the report?
No, Your Honor, we are not.
Before the court passes sentence, then, Ms. Underwood, is there anything you want to say on behalf of Mr. Garcia?
Thank you, Your Honor. Mr. Garcia, first of all, fully acknowledges his failures in this matter, Your Honor. He understands that Ms. Teskey worked very hard to try to get Mr. Garcia successful at probation, and she wasn't able to do that. And that's on him. He understands that. And we understand the recommendation of the probation department for a year in jail with credit for the 300 some days Mr. Garcia has put in, and we would ask the court to go with the recommendation today.
Mr. Garcia, is there anything you would like to say on your own behalf before the court passes sentence?
No, Your Honor, I'm just here to take accountability today.
All right, so in the 21-20575-FC file, Mr. Garcia was convicted of second-degree home invasion. The original guidelines in that case were 29 to 57 months. In the 25-22233-FH case, Mr. Garcia was convicted of assaulting, resisting, obstructing a police officer with the original guidelines being 2 to 17 months. Rather than impose those the sentence in accordance with the sentencing guidelines, Mr. Garcia received a sentence that was a downward departure from the sentencing guideline. In order to place him on probation, ultimately was given an opportunity at drug court, but simply didn't participate in that and continue to use controlled substances, and in doing so, continue to violate the law. I understand that the recommendation from the probation officer is for 1 year in jail and revoking Mr. Garcia's probation. But I don't think at this point that continuation of a downward departure sentence is appropriate. And I think it's more appropriate to sentence Mr. Garcia under the original guidelines that applied to his cases, specifically with respect to the home invasion 29 to 57 month guidelines that were calculated for that file. Therefore, it's going to be the sense of the court that Mr. Garcia served a period of 29 months to 15 years with Michigan Department of Corrections with respect to file 21-20575-FC, and a period of 17 months to 2 years with the Michigan Department of Corrections with respect to file 25-22233-FH. Mr. Garcia, you do have the right to request an appeal of your sentence. We're going to send to you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those forms, you need to sign 1 copy for each file and return those to the court. That indicates that you received your copies of those forms. If you would like to request an appeal and have an attorney appointed for you to do that, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
Your Honor, due to him being on parole at the time of the offense, he will not receive any jail credit on either of these cases, correct? And he will be ordered to serve consecutively to his current parole term.
Your Honor, Mr. Garcia is on parole at this time. I believe that was probably.
All right. If that's the case, then yes, Ms. Teskey is correct. He's not entitled to credit for the offense based on his status as being on parole.
Thank you.
Does that mean the time that I've been in here right now, or the 313 days?
It means the time that you've been in, it means the time you've been in here right now is credited toward whatever you're on parole for.
So what, do I still get the 313 days credit, or you're saying I don't get that credit?
That already been given to him?
No, Your Honor, when it's a local probation sentence, he is afforded that, but when they go to prison, they don't get any of that jail credit.
All right, so the answer is no, then, Mr. Garcia, you do not get that 313 days. You can let the officer with you know that you are done with court for today.
Thank you, Judge.
Okay, so there is the file.
Probation was already put on the file. There was a third file, but
Okay, I also had a sentencing. So we
Yeah,
just
we
need to
just-
dismiss it.
Is my
All right,
docket concluded, Your Honor?
I'm sorry,
Is my docket concluded?
I've got an extradition for you.
Oh. Thank you.
Sir, you're Mr. West?
Yes, sir. Yes, sir.
This is file 26-22643-AX, People of the State of Michigan versus Wendell Charles West Jr. We are here today for an extradition hearing, and we are proceeding today by video conference.
Yes, sir.
Excuse me, I'm sorry, just 1 second. Mr. West, this is a proceeding to determine whether you wish to waive your rights of extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand from another state for your surrender and to return to that state to face the crime with which you've been charged in that state. You've been charged in the state of Alabama, Franklin County, Alabama, with the offense of possession of a firearm by a forbidden person and trafficking marijuana. We cannot, which are felonies in that state. We cannot, in the state of Michigan, determine the truth or falsity of the charges made against you in the state of Alabama. You do not have to waive your right to extradition. You can require that the governor of the state of Alabama make a demand upon the governor of the state of Michigan for a warrant for your extradition. You do have the right to demand and procure legal counsel. If you cannot afford an attorney, the court will appoint one for you at public expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand those rights, Mr. West?
Yes, I do, sir.
Do you want to be represented by an attorney today?
Yes, sir.
Have the ability to pay for your own attorney?
No, sir.
All right, I'll put you in a breakout session with Ms. Underwood right now.
Thank you.
Is Mr. Fry?
Just get some crimes that were out in the hallway. Corey, corrections, I emailed her. So it's still going.
We have Ms. Underwood and Mr. West back from the breakout session. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. West this morning, Your Honor.
And do you know how Mr. West wishes to proceed?
Mr. West wishes to assert his rights, Your Honor. He will not agree to go back to Alabama. So I guess the prosecutor's office or the court are going to have to ask for a governor's warrant, Your Honor.
All right, I will set this for a status conference then in approximately 30 days. Let's go with June 24th at 8:15 a.m.
Okay, and is the prosecutor responsible for seeking that warrant, Your Honor?
Well, it's the state of Alabama that has to seek the warrant from the state of Michigan.
Thank you.
Do I get a set up of a bond? Do I get a bond? Request a bond? I'm on probation here. I haven't been out, I've been here for 5 months.
Your Honor, Mr. West is on probation with Ms. Holly, Your Honor. I believe if a bond is possible.
Mr. West, please stop talking. Your attorney's trying to address the court and I can't have two people talking at the same time.
Thank you. Mr. West is on probation with Ms. Holly, Your Honor. I believe that includes such things as reporting and outpatient treatment. I believe Mr. West could be monitored appropriately. He obviously doesn't want to go anywhere. He wants to stay here. I would ask if a bond is at all possible, Your Honor, under these circumstances, that the court would grant one.
Are you currently serving a sentence, Mr. West?
I completed my sentence that you sentenced me to 6 months in jail and gave me credited for time served. And it was up on Friday of last week. And then this warrant came up, this hold came up, and I've been here since then, but I was here for 5 months. I've worked here in the kitchen. Now been working in the laundry room. I've been I'm on a probation with Mrs. Holly. I have to report. I have to go to 90 meetings in 90 days. I'll have to do outpatient treatment. I've got to pay him $2,656, and most likely I'll be reporting every week to her and keeping in contact with her. I have a house here in Britain. I have a job. All I have to do is get out, and I can be working tomorrow or the next day until they find me a place, to work at. I've been working with this company off and on for 20 some years. And I not going nowhere. I ain't going to Alabama. I ain't going anywhere. I want to get all this stuff cleared up. I want to do the right thing, and I'm trying to do that right now. And I can proceed with this stuff.
You got felony warrants in the state of Alabama that need to be cleared up. Is the problem?
Yeah. But it's, I know it's marijuana.
I'm not going to make a decision on bond right now. I'm going to take this under advisement. I'll make a decision probably later today and issue a written order for a bond if I decide on that.
Thank you, Your Honor.
Thank you much. I appreciate you.
All right, so Mr. West, you can let the officer with you know that you're done with court for today.
Yes, sir. Thank you.
Thank you. Okay, I think we're all set. Thank you, Rhonda.